All right, welcome to the House Environment Committee. We are continuing our afternoon meeting with a further committee discussion, possibly of H 723 and act relating to posting of land, this time with our legislative council. Welcome back.
Thank you. Bradley Shulman, Office of Legislative Counsel, and I'm here to discuss Act 723. I'd like to start today's discussion by answering a question from last time, if I may.
Please.
So I'm going to share my screen. So last time we had a question on the how private property rights are included in the Vermont Constitution. So it's Article 1. And all persons are born equally free and independent and have certain natural, inherent, and unalienable rights, amongst which are the enjoying and defending of life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. Therefore, slavery and indentured servitude in any form are prohibited. So it's pretty strong language protecting individuals' rights, including the right to protect their property. We have some other articles that also touch on private property rights. So the private property ought to be subservient to public uses when necessity provides it. Nevertheless, when any person's property is taken for the use of the public, the owner ought to receive an equivalent in money. Kind of a type of takings clause, typical in many states' constitutions. But if the state has to take private property for some reason, they have to compensate an individual. And you see that coming up on things, not necessarily in Vermont, but for example, out west, when they're trying to build high-speed rail in California, things will come up like eminent domain, takings, and things of that sort, building pipes across people's properties and things like that. Something might come up with relation to that. Our search and seizure article, the people have the right to hold themselves, their houses, papers, and possessions free from search and seizure, and therefore warrants without oath or affirmation first made, affording sufficient foundation for them, and whereby any officer or messenger may be commanded or required to search suspected places or to seize any person or persons, his or her property not particularly described, are contrary to that right and ought not be granted. This is related to the search and seizure of property by police. Sometimes it does come into consideration when we're talking about game wardens and game wardens entering property for search purposes, and problems that might result from there. And then we scroll all the way. I should just do a Control F here just to. Yeah. And then the other place in the statute where private property is mentioned is Section 67, which is the topic of conversation for us today. The inhabitants of this state shall have the liberty in seasonable times to hunt and fowl on the lands they hold, and on other lands not enclosed, and in like manner to fish on all boatable and other waters, not private property, under proper regulations to be made and provided by the General Assembly. It's interesting here. We've been talking a lot about the first part of this constitutional provision, the right to hunt on lands not enclosed, and defining that. But the provision does go on to put in an awkwardly placed parentheses, not private property. Does that modify only other waters? Does that modify this whole section? I think that's an open question for the Supreme Court. That said, I think the job, or not the job, but the task with this bill is to balance private property rights, which are very well protected in Vermont's Constitution, with other rights that sometimes conflict, and the right to enter a person's property to hunt and fowl in seasonable times. And I will also point out that this provision, under proper regulations to be made and provided by the General Assembly, specifically says to the legislature, this is something you folks, doesn't say you folks, this is something the legislature has to deal with, unfortunately, or fortunately, to grapple with these sticky issues. So I just wanted to go over and give that context. I know we did have that question earlier, and just kind of provide that constitutional framework because that is the law, the way up here law. It doesn't give us a lot of instruction, and so when we're kind of in the nitty gritty of providing instruction to property owners, to hunters, to game wardens in drafting these statutes, well, keeping that kind of framework in mind is helpful framing. And it was a good question to kind of bring us back to that point. I'm happy to answer any other questions the committee might have at this point, discuss particulars of the bill.
Do folks have questions on this? I guess I'm kind of curious about the subsections versus the articles at the beginning. You know about how those relate? I mean, were they all original?
I know that this one was in yeah, 1777. Yes, it was. So I don't know if all of these are original. And I'm not familiar with the extent the Constitution has been amended over the years. I can look into that, but it's regardless, once the Constitution amended, whether it's an amendment or an original provision, it has equal force in terms of guiding those principles. So it's just like the Bill of Rights in the Constitution. The Bill of Rights has equal force. The first 10 amendments has equal force as the rest of the amendments, has equal force to the text of the Constitution. It's all part of that same framework with the same legal authority.
Same as the subsections.
Yeah, exactly.
Okay.
Exactly.
Okay. Members have questions on this?
Question. I'm not understanding the conflict. I mean, I feel like hunters have a constitutional right to hunt. People have a constitutional right to enclose their land.
Mhm.
And I mean, unless hunters feel like that's unfair or something, there's a conflict, but I don't see that there's a legal conflict because it's pretty clear. And I think what we're talking about is people who are not following the law. And just trying to figure out in terms of the laws, what laws do we need to create for the Department of Fish and Wildlife to maybe enforce in terms of enforcement of the law. Does that make sense?
Yeah. I mean, a person could think about the rights as kind of butting up against each other, as in conflict.
Mhm.
And you might be thinking of the rights as a more, I don't want to say yin and yang because I'm not familiar with that religion, but it's that kind of they're in opposition, but they work together,
Mhm.
right? And so instead of opposing each other and fighting, it's opposition, but it's working together to to create a framework where we all live together in that environment. So that framing could be different. You're exactly right.
Further questions on this? No? Okay. Did you set Bradley some questions? Do you want to talk about this?
Oh, yeah, I had gotten at least some email from residents of the state bringing up in response to a couple of things we've done in committee, which I thought were worth following up with Bradley. And so I asked him two sets of questions. One was about the language that we use for the reasonableness standard. And because we had gotten some language that was proposing a different way to word that. I think it amounted to largely the same thing. But it was definitely shorter. So perhaps clearer or perhaps not, but that was the one piece, and that might be something that we can look at together. Would you be prepared to do that, Bradley?
Yes, just one moment. I'm just pulling up an email. Okay. Um, so have the language that you had sent me to consider was a technical defect in placement, spacing, color, wording, or dimension shall not invalidate the notice. A notice under the section if the notice clearly communicates to a reasonable person that entry for hunting, fishing, trapping, or taking of game is prohibited or allowed by permission only. And I think that that's fine language. It accomplishes a similar goal. I would amend this to if the committee keeps paint markings in the bill, I would amend this to specify that specify notice signs or paint markings. I can't remember the. I mean, I guess I have it before me, but the language I think I referred to the subsections. Yeah, I referred to the subdivisions in the statute in the language that I drafted. But if you want more plain language, I mean, you could say notice signs or paint markings made pursuant to this section. I would say. So a little bit of wordsmithing, but I think that the thrust is there.
Either approach is really doing the same thing in your opinion? Is there, they feel different when you read them, but, so that's what I was struggling with, and that's why I asked for your input, was that they felt different reading them, but my not so legal mind was really unsure if they were actually accomplishing anything,
The big,
even in a small way.
sorry, yeah. I think the biggest difference, and I struggle with how to put this, but there isn't as much of a limiting factor on the proposed language here. And so the limiting factor, and I struggled with this myself, but the limiting factor would be accidental or unintentional deviations from the requirements of the subdivision, which is the language that I proposed based on feedback from the committee. And so that requires some thoughtfulness on, or that requires some understanding of what the property owner is doing, or what the property owner is thinking. This doesn't necessarily do that, right? You know, so if a property owner potentially knows that a sign is defective, there isn't an obligation to fix it. And so there could be a technical defect, but they don't mind that there's a technical defect and leave it there. And that could be fine for the committee. If the committee is, because that is a policy choice, you know, if a property owner knows that the limit is 400 feet and it's 401 feet because the next nearest tree was 401 feet and they know it's more than that and they post it anyway, that would potentially be allowed under the statute, even if the property owner knows that. And so I would say that is the difference. The knowledge, what we're talking about is the knowledge of the property owner about the defect and whether it's okay for the committee to, whether that kind of scenario is okay for the committee.
Right.
If they're out of OSHA purple and they just use regular purple, you know, and they know that they've used the regular purple when the statute calls for OSHA purple, is that okay for the committee?
Right.
And so that would be the choice.
Thank you. That's very helpful. I like having that distinguishing between trying to figure out what the landowner knows at the time of posting or doesn't know. That seems important because that also seems like it would be actually really hard for a warden to know what that actually is.
I think that's right. And I think that's, this isn't a criminal law statute. This isn't criminal law things. You know, if you post your land incorrectly, you're not going to jail. This is not criminal law. That's by analogy, these are the things that criminal law kind of deal with, is like your mental state and what you were thinking at the time. So were you not thinking at all? Were you just being negligent? Did you know, and things like that, right? And so, but you're right. So introducing that level of scrutiny that the game board would have to do to a property owner's mental state it's the wrong word, their thinking at the time, would be hard. Not impossible, but hard.
And the other piece that I asked for feedback on was we heard this morning from the Colonel about basically agents and being allowed to post property for you, and heard from the same resident that it's not clear in the law whether agents are actually permissible, that it's not in the statute that you can hire someone to post your land for you. But I'm going to characterize Bradley's response as basically saying it's okay that it's not specifically referenced, that ordinarily we allow people to do things for us, and unless statute tells us otherwise, that's the presumption. Did I characterize that correctly?
I think that's right. I think that's right. And I can provide some more context, but basically, there's a common law legal doctrine called agency, where you're a principal, right? And you have the authority to do something, and you can delegate that authority to someone else. And so often we might have a legal duty to maintain our homes, and so you can delegate the authority to do the physical work in your home to make it safe. But under the law, sometimes that delegation needs to be in writing, and sometimes there are some things that can't be delegated. And usually it's the law statute that says that. And so if you're going to sell real property, you need a written document called a power of attorney to sell someone else's real property if you're an agent. That's a classic example. And then some other authority, some things can't be delegated, like the duty to maintain your home. So you can delegate the physical work, but you can't delegate the legal responsibility you have to your guests if your guest is harmed that you didn't repair the floor, right? And so you can see how that might get a little tricky. So for this statute, I think that that's exactly right. I don't see any requirement that the delegation needs to be in writing. I don't see a prohibition on the delegation. That said, people could make the argument, and if like this community member did make, and if that is a concern, the committee could consider changing the statutes to an owner's designee, or a person having exclusive right, and so forth. We'll point out that there is another provision in the statute that contemplates it's not the owner. There's subsection C says a person or the owner or person posting the lands. And so a different subsection of the same statute already contemplates that it might not actually be the owner posting the land. And so, that is a policy choice.
Representative North.
Sure. Thanks, Bradley, especially for clarifying the constitutional thing. I know you're not a judge, but we heard this morning from that ordinance need a very clear and high bar for charging somebody with violating posting signs. The hidden closing must be essentially perfect. It's dated exactly correct, technically correct all the way around. And that's troubled some of us, and that's a reasonableness clause. So his assertion was that the reasonableness clause softens the posting requirement so much so that a judge might feel that, just like in trespassing signs, it's not chargeable on the first offense, and you just have to give them a written warning. Because it's not a high bar as it was. It's a little softer, and so they might not have known, they might not have seen the sign, or whereas a really high bar for the enclosing, you can charge them on the first offense. What's your feeling on that? legal perspective?
So, that's a good question. Because it touches on law enforcement's, I don't want to say inherent discretion. But there's something fundamental to the job where you're making judgment calls when you're on the scene. Right? And and how law enforcement exercises that judgment might vary from officer to officer. So I am not familiar with a judge who would say that just because you did something once, like you get a freebie, essentially, right? I'm not familiar with a judge who would say, if you did something bad once, we're letting you go for the sole reason you did it once. There might be some other reasons, like I didn't know, I didn't see the sign. You can't prove that I saw the sign. Well, if I don't, remind me to talk about, you can't prove that I saw the sign, because that's important. Or you could say, I made a good faith mistake because I don't know how to read, or something like that, you know. And so there might be more to it when a judge is making a decision than just, it was your first offense, so I'm letting you go. That said, it's not unheard of that a judge might do something like that. And regardless of what kind of statute you might have, that might be the case. And so these are judgment calls that law enforcement have to make. The reasonableness standard, and so if you go into court and you say, I didn't see the sign. The reasonableness standard is an objective standard. Okay. So it doesn't necessarily mean, under the law, reasonableness does not mean that you have to prove that I, the person who has trespassed, actually saw the sign. A reasonableness standard means that you have to prove that a reasonable person would have seen the sign. So, and you could think about it differently, right? And so if it was, if the statute says, in order to charge someone, they actually have to have seen the sign. Actually seeing the sign is what we call a subjective standard. And so if the statute said, I have to actually see the sign in order to be prohibited, I could just potentially put my blinders on and not see the sign, get into the property, and go about my business. I didn't see the sign. I didn't actually see the sign. Now, you know, if I'm intentionally doing this, right? But, you know, you can imagine a scenario where maybe the sun's in my eyes, I didn't see anything, and now the sun's not in my eyes, and lo and behold, I have crossed the threshold and didn't see the sign. That I didn't actually see the sign, so can I be charged under the statute? Perhaps not. But when we have a reasonableness standard, a reasonably prudent person, that puts the onus on the legal analysis becomes, what would a reasonable person see? So if you have posting signs in accordance with the law would say that as long as your land is posted in accordance with the law, a reasonable person would know to look for it. And especially if you have signs posted more often, as we've discussed several times at the committee, if you have signs posted more often, a reasonable person would see those signs, would know to look for those signs, because we know that when we go out on other people's property, we think it's fair to say that most people know that some people don't want you on their property, and you'll post a sign saying, I don't want you here, in one way or another. And I think most people know to actually keep an eye out for those things. So that's the difference, right? And so reasonableness standard is actually an objective standard about what a reasonable person would do, and less about what actually the mind state of someone who actually trespassed. That said, criminal law is tricky. And I think the game warden is correct that proving these things is very hard and time consuming for law enforcement. And the other question would be, are these enforcement priorities when resources are so limited?
So what type of reasonableness, how do you invoke that reasonableness standard? What kind of language would be necessary to invoke that properly so that it's an objective standard?
Yeah, you would just have language kind of like the language that was proposed by email earlier, or the language that is proposed here.
Right, language that's in there now. Reasonableness.
Yes, need a reasonable person to believe. Yeah, and so what we have here would be the reasonable person to believe that hunting, fishing, trapping, or taking of game is prohibited on the land. It's tricky though. I agree with the game warden that it is not. It is difficult to charge. It is difficult to prosecute. There are limited resources to do these things. And I think that's true in the law more broadly.
That does sound a little different logical analysis than what we heard this morning, I gotta admit.
Yeah, I think the legal standards are they're tricky. They're tricky to kind of get around, and yeah, I don't have any more to add.
Thank you so much for your answer.
That was very helpful though, and what court would hear a charge of trespass in this hunting case?
There was a statute that was passed that made jurisdiction for these crimes, most Fish and Wild crimes, the civil court, unless it's a repeated violation. I would need to pull up the actual statute, and the number is escaping my mind.
The Judicial Bureau?
It would be the civil superior court. And let's see if I can pull it up. But I might need to get back to you on that piece.
Representative North.
I'd like to follow on with that question and specific to the wardens within wildlife. Do they have unique authority over what we might consider the authority of a police officer to kind of be the judge as well? Or are they just like a police officer who filed a charge and then it needs to go get heard in court?
Yeah, the game warden would not be the judge
Or just not?
in this instance. No.
So he just hands patient essentially, and then somebody, even in the case of like awarding points for breaking out.
He's the highest level of legal authority. I mean, his enforcement in the state, his powers are above the state.
But he's still not a judge. The case, his citation would still get heard by a judge, even for assigning points.
Even for signing bonds.
Yes,
Okay, I just didn't know that.
but they were the equivalent of state police.
They are above state. They have powers above state troopers. They're the highest law enforcement authority in the state.
Interesting. Go ahead.
Are you looking for something? Are you?
I mean, I'm multitasking, which I shouldn't be doing. So I was looking for the statute that you asked me for earlier, but we can continue. Yeah.
To further questions for Bradley? Representative Hoyt.
Yeah, so with the Judicial Bureau, they get all the motor vehicle, alcohol, tobacco, fish hunting and trapping stuff, right? And so, it's kind of like you get a citation, right? And people are more likely just to pay a fine and actually go contest in court for the most part. It depends ultimately on what the penalty is. And what's the penalty again for like taking down a posted sign? Like
25.
Not much.
It's not much, right?
Yeah, it's $25 to $100.
Okay, so someone, I get.
Said something different. It's very hard to get
It's,
So I get,
great answers on fish and wildlife things. That's what we're learning.
that is,
so I get cited for that, I just can go pay it, right? Or just send my money in. I don't have to go.
because it has come up before, that is 10 VSA 5204. A person without written consent of the owner, a person having exclusive right to take animals, or carries or possesses a firearm or bow to trap on a private preserve posted under this title, or mutilates or defaces the notice called for in section 5201B of this title shall be fined not less than $25 nor more than $100. So 5204.
Representative Austin.
So can we make that a violation under Fish and Wildlife and assign points to it? Or would that be Fish and Wildlife that would do that?
I don't see a reason why it couldn't be a points violation. And I did find the statute that I was thinking about earlier, and it does not answer the question of whether this fine would be adjudicated in criminal court or civil court. So I will get back to the committee on that. Let's get back to the committee.
So I just looked up Title 10, Section 4198, and they have the same law enforcement as state police. Sheriffs, constables, and police. Same law authority. So, is there further questions for Bradley on where we are now? Representative Tanglavia.
I thought after all the discussions, and maybe I'm looking at the wrong version. 1.1, are we still on 1.1, or is there another one that I hit the refresh button and I didn't get it?
So we are on H 723, bill as introduced. Nope, actually, that's incorrect. 1.1 for the amendments. I'm sorry. So there is an amendment draft 1.1.
1:08 PM.
Yes, at 1:08 PM, 210.
But when we were talking about this yesterday, the paint was getting pulled out.
We hadn't fully talked about it.
Okay.
And I have to say, like, I'm feeling, we keep talking circles around this topic, and it feels like a lot of the things we're trying to solve would still be solved in a much more straightforward way with paint. So I'm not personally ready to change that. I feel like we've gotten into a topic that, we're hearing a lot of feedback, and a lot of folks are very interested in the topic. And I think leaving it as is and having time for folks to weigh in is maybe an important place for where we are right now. I feel like we've been talking about easing the burden of posting. I keep coming back to, like, how are we actually doing that with all of the things we're talking about? And it's a clear and a high bar of posting. And I'm thinking, wow, paint makes a clear and a high bar. We're hearing from landowners who are really seeking relief, and the reminder of your analogy, I think, of the tension between the rights that we are charged with in statute under the right to hunt and fish. We are charged with seeking that balance. I'm having a hard time with where we are, where we've been talking about.
Could we still have it so that we had an ending date on the post, they wouldn't have to post every year, date it every year. That they wouldn't have to date the posting every year, that we could do a 3-year.
We could, yes.
And then have an
signage.
ending date, because that seemed to be a real hardship, if we could just do that every year. To put.
To make signs easier, yes.
And what about the penalties, the adding points?
For the moving someone's sign.
Yeah. Removing someone's signs or getting on someone's property where there are signs all around.
Oh, did we determine that that's not a point violation? It's just a fine, it's a citation.
I don't think so. I could double check, but I don't think it's a points violation.
Because then the Fish and Wildlife could just give that, right? They wouldn't have to go to court or anything, right? Or would they'd still have to go to,
I mean, a person probably could appeal to a court if they wanted to.
but the game warden could just say,
He's correct. Making my note here.
thank you.
So I have to beg to differ with you, Chair, on that, on the paint. I don't see that it's any different or better. If anything, it's significantly worse than a sign.
Worse in what way?
Worse in that it doesn't carry the information that a sign carries. There's lots of different versions of signs you can put up. You can prohibit hunting, you can prohibit fishing, you can prohibit trapping, you can prohibit trespassing, you can prohibit all of that, some of it. So knowledge of what a paint swap means is ambiguous. It doesn't carry a date, it doesn't carry contact information. All it is color on a tree. There's lots of colors on lots of trees throughout the woods all over the place, hiking trails. It's not permanent, so it doesn't solve the permanence problem. It does fade over time, degrade over time. You'd have to go back and refresh it. So it doesn't resolve any of the accessibility, even the way it's currently, where you got to paint every 100 feet rather than every 400 feet. So you got to do more, 4 times as much. So to me, it does the opposite of what we're trying to help people do. I much prefer what Sarita has proposed, and then others have proposed, of just extending it to 3, maybe 5. I think 3 is what most people are saying. 3 years, dated on the signs, very clear. Each sign, whether you want permission or not, whether you want hunting or fishing or trapping or not, or trespassing or not, very clear on the sign what you're allowing, what you're not allowing, and clearly dated. So it has an expiration, clearly dated, so you know you've been there within the last 3 years to make sure it's correct. That just seems like the right level of responsibility to apply, rather than throwing up a piece of paint and then put it. Yeah, and then you got to get all technical, like on the type of paint and how wide it is. What if it's too wide? Is it wide enough? It's not wide enough. It's the wrong direction. And I don't know. It's just too many unconstrained variables with the paint, and too much ambiguity for it to actually work. I know other states do it, but several other states do it, and seems to hold water there. But they don't have the 1777 constitutional article that we do. So
Well, they do. We had Bradley focus on the states that have purple paint and a constitutional right.
but even their constitutional rights are different though.
And I guess, yeah, we can direct the clarity
Yes,
statute.
right. Right. I agree with that. So
Yep. And
it's incumbent on us to.
we are heading into town meeting week. We are hearing from a lot of property owners who support this idea of paint. And I think it behooves us to listen to them.
There were a whole pile of people in here that came physically to the State House day or two ago that don't approve of it, so.
It's a,
All right. With that, we were also going to talk about the miscellaneous bill from Fish.
Okay. So where I left off yesterday was page 4. We are on draft request 26-0783, draft 1.1. I left off on page 4, section 2. And so this section changes when licenses expire. Currently, all annual licenses shall expire on December 31st of the year for which they were issued. This bill would change that to be or 365 days after the date on which they are issued as determined by the commission.
That feels confusing to me. So middle of November rifle season, your license could expire because you bought it in the middle of November the year before.
Potentially,
Yeah,
that is a potential issue.
I don't know why.
Yeah, this strikes me as strange too. I mean, I can see one or the other, right? It goes 365 days or it expires on a certain date. So another thing is, I don't know if you had any input on why they're asking for this, but like, what's the idea of giving the commissioner the authority to sort of determine which one it is? Do you know what that's, I mean, it's something they'll have to explain, I suppose.
I think that's exactly right. I did not have input on this. I put it into our format and
They did present it and I think they found, they were hoping that more people would be open to buying a license if they waited later in a year,
Okay,
you know, a couple weeks left in the whatever season, and then
and the commissioner could say, okay, yeah, that's good.
they might be more inclined to buy a license that year. But what line are we on? What page and line?
you're on now page 5, lines 5 and 6.
Thank you. Page 4.
Moving on. So the next section is a controversial one, and section 3 is licenses. So I listed this piece out just to show the kinds of things that there are licenses for on page 5. We're moving over to page 6. Some more kinds of things that there are licenses for, and then the change. If the board determines that it is necessary to issue or require additional tags or permits that are not otherwise identified in section in order to maintain the best health, population, and utilization levels of regulated species, the department may issue such tags and permits and may assess a fee for such tags and permits of no more than $40. So this would give, this would broaden the department's authority to issue licenses to cover things that they haven't contemplated, that are not contemplated in statute. So it might be like a second turkey, I think, or something of the sort that they've determined that that is not contemplated in statute. And that does represent a change from but it represents a change from current law. Current law, if they wanted to add or change those fees, or excuse me, if they wanted to add an additional fee, so this does not give them the authority to change a fee, but if they wanted to add a fee for something that's not contemplated in the statute, then they would have to go to the legislature to do that.
Representative Sackler.
Sorry, I'm a little confused. I'm reading this and I'm thinking it's saying that the Fish and Wildlife Board determines whether an additional tag or permit is needed. And that they can do so, and that if they do, that the department can issue such tags and assess a fee of no more than $40. And is that the plain reading? I mean,
That is correct. That is correct. And so, oh, go ahead.
no, and then my question then was also, it says the department, would that mean that it's the commissioner of Fish and Wildlife that would then be the person who sets that fee?
Yes.
So send the bill to Ways and Means and they will take deference with that.
I mean, it seems to make sense to me in terms of that they have some flexibility about the health population and utilization levels of regular, I mean, they must change. They can't stay the same every year. There's an abundance of turkey. You know, they probably, it seems like they could issue a 2 turkey, whatever. I mean, I don't know what the downside of is letting them adjust things according to how wildlife or you know, the numbers exist every year, and they must be different. If there's more deer, that there should be more, you know, people should be allowed to take more deer. Is that, am I reading that wrong? Or-
I don't think you're reading wrong. I think, that I'm curious why this is necessary. Like, isn't the department, like it says a hunting license is $28, and that usually that comes with tags that are related to what that take for that year is.
It's changed up. The reason that they've asked for this is that the deer rules have changed for next year, set last year. So now there's the possibility of being able to purchase a second buck tag if you meet the criteria to do that. And there's no set price on it. So this year, everybody that qualifies for that second buck tag will get it for free. The commissioner wanted the ability. Pretty simple to me. Pretty simple. We conflate these things.
It is simple, but I'm wondering if this language is actually makes it more complicated than it needs to be. Because if the department is coming to us with this language because of the specific problem that you just talked about, they're actually asking for not that, but something which could include that, but could include all sorts of other things as well. And then being given the ability to set the number as per their discretion, which would be really different than, we just saw this whole list, right, which is all in statute. And this would be really different. This would be a fee that would be just set by the commissioner, right? And so it would be like you couldn't, if you went and searched our statute for fees and saw this list, you'd see all these, but then if you wanted to know what this second deer tag cost, you wouldn't be able to find it in the same way.
I
think it would be, I'm sorry, I think it would be because that might change seasonal depending on the population.
It's specific to tags. It's specific. It says the department may issue such tags and permits and may assess a fee for such tags and permits of no more than 40. Has nothing to do with setting license costs of trapping or hunting or any of that. It's specific. The language is right there. It's clear.
The above language, it says bear tag, additional deer archery tag, and they have prices associated with. Wouldn't this be the same kind of thing as those?
With the existing tags, but they're not changing license fees. It says tags, such tags and permits. That's all he's asking.
But you're pointing out, Larry, is that on page 6, line 2 and 3, there are things called tags, bear tag
Yes, exactly.
and deer archery tag. And I'm not a hunter, so I don't.
Well, it would include those tags. So yeah, they could change. If you wanted to say the bear tag was $10 and you wanted to change it up to 40, you could do that. That's all it's saying. It's not talking about changing the actual cost of hunting license.
That's a good question for Bradley, actually. Under this new language, would the commissioner be able to alter the what's said in statute above for bear tags or additional deer archery tags?
No,
Because that's the statute and
that's correct.
he doesn't have that authority.
That's correct. And so this statute would delegate the authority to do things that are not contemplated by the statute, does not delegate the authority to rewrite the statute.
Do we know if there's other instances where commissioner has the authority to set the prices of or fees of permits or tags currently, or if there are other tags or permit fees that are applicable for various kinds of hunting but are not in statute?
That is a good question. And because I'm not familiar with a scenario quite like this where, part of most of it is contemplated by statute, but then that authority is delegated for things that the statute doesn't contemplate. I can't come up with an example. I think the delegating the fee authority is, certainly a sensitive political issue, with reasons on both sides for sure. And we see that authority with the Department of Fish and Wildlife, with setting some certain fees, especially with relation to their camps and things of the sort. We see that authority with Parks and Recreation, setting park fee, entrance fees and things of that sort, where it's delegated. But I can't recall a scenario in either of those situations where authority is both say that these are some of the fees and you get to delegate the rest. I can't think of anything.
It seems like it would be simpler if we're trying to solve this particular problem of this additional deer tag. The department to have come in and said, additional deer tags, as necessary, depending upon perhaps this, what's going on with the season, are this amount of money, and it would be consistent with the other parts of our statute.
I'm sorry, I think I missed the question.
I guess it's not really a question. I think I'm just pointing out that if they had done it that way, if they had brought something like language to us like that would have been consistent with the other parts of statute.
Yeah.
I think that's one way to think about it. And I think the thrust of this language, and I don't want to put words in their mouth, right? But I think the thrust of this is to offer some flexibility for situations that are not anticipated. I think the impetus for these is more testimony from them. But you're absolutely right that there could be different ways to go about achieving a goal. The goal as we understand it here.
Representative Austin.
I don't understand the hesitation. I mean, I think we're talking about, a population that probably changes every season. And if the commission wants to maintain the best health population and utilization levels of a regulated species, I feel like she needs some flexibility to be able to do that. They can't go over $40. It's not like they're gonna make a killing on this, and I just think that makes sense to me.
Yeah, it's just, it's in the context of what Representative Sapkowitz has been just asking questions about, which is that fees are set in statute, and we haven't had a fee bill in 10 years. And so the department's seeking some flexibility in that. I'm in that light, I would say. And our Ways and Means Committee will have opinions about this. Then they may ask our opinion, and so we are trying to understand it so that we can make a recommendation to them if we send it on to them.
Department already has flexibility regarding moose. We had 180 permits last year. This year they're going to be down to 80.
Yeah. That's
That's
the,
the flexibility they need to manage that loose herd. I think just extend it across one more speech.
So is it just assessing the fee that they're looking at? Being able to and be flexible under $40?
I think the flexibility here would be for tags that are not contemplated. So with the moose, for example, if they have 180 moose licenses and now they have 70 or what, I'm sorry if I misrepresented the numbers. But that doesn't affect the cost of the license, right? It just affects the number of the licenses. This statute would, as proposed, this bill proposes to give them the authority for a license that has not been contemplated by statute. And so a new scenario. So instead of just one moose, it's two moose, an additional moose tag. Actually, I don't know if there's, it says it's moose license. But the idea would be to, if there is something that comes up, to be able to charge for something that is not anticipated in statute.
It's to address additional tags and the lottery system. That's what it's to address. Additional tags and the lottery system. A few years back, there was one bear tag. When you bought your license, you got a bear tag. It was good for the whole season. The department changed that. They had an early bear season tag, and a late bear season tag. So if they didn't have the ability to do this, they couldn't assess a fee to the tag immediately. And that's all they're asking to do. Just don't understand why this is.
I think it's okay for us to understand the language that we're being asked to. We're just having a discussion. I think that's what our job is here.
Well, it is, but it's pretty clear, Chair Sheldon. It's pretty clear to me. And I'm not the sharpest tool bag sitting in this thing.
But you're a hunter
It
and you know the system.
has nothing to do with hunting. It's just the language is clear. I mean, that's all they're asking to do.
I would say the language is really clear. What I'm wondering about is whether given our history of how we assess fees in statute, whether it's appropriate to delegate that authority to the commissioner.
Question.
Representative Tagliavia.
Thank you. I see your point. I think because of when we're in session versus when the decisions are made about the number of tags to issue after you bought your license, that we would not be in session to be able to say, yes, you can assess this fee, giving them the latitude to do that, whether it be bear tags or additional deer tags, giving the department the latitude to do that would alleviate the question of whether we're in session to help the department actually assess the dollar amount, whether it be called a tag or a license. And maybe after we've beaten this to death, maybe the department should come in and help us.
I think we understand the question now then. So thank you.
And if I may, I do want to just remind the committee that there was a fourth item that was asked at the 11th hour to be put into this bill, but I never received instruction from the committee to put it in.
What is that?
It was, and now I'm not recalling it, but there was some session law that they were looking to repeal from a long time ago. That had it up and now it's not. So my apologies.
Maybe we can look at it the next time we hear from you on this.
Yes, and they are appealing and I can send it to the committee because it sounds like the committee might not have it. I believe Hannah might have gone over it in her testimony when she was here, or Attorney Smith might have gone over it in her testimony when she was here several weeks ago. But I will send it to the committee so you can take a look at that.
That'd be great.
All right.
Thank you so much.
Thank you so much.
Thank you.
And Mike, just very briefly before you go, Bradley,
Yes.
on page 4, on line 12, we talked about these sections, which we talked about what they were, that these were the ones that were staying, and all the other ones were being moved in terms of their points. But we didn't actually talk about the ones that are going to be fewer points.
We mentioned those earlier. I can go over them again.
We don't have to do it now. I thought we did not go through the list in appendix section 30, in appendix 37, that particular list.
So we went through appendix 37 twice, but I can go over it again the next time.
I guess okay, that wasn't my recollection.
No, and it's fine. Because appendix 37 has the novice season, and I did my spiel on what novice season was.
Okay,
The 10 point.
maybe I should just look at that again.
But
So ask Fish and Wildlife for a English language sort of
Yeah.
summary of this, so that it will be easier to, you didn't have to keep going back and forth.
yes, and I think
I
that's,
agreed they would do that.
Yeah.
yeah, and I think that's key to kind of keeping these straight, because it is confusing how it's laid out in statute. And so, thank you.
Thank you.
I did post the amendment. Okay, so it should load.
Is that the section 4 from? Okay, thank you. Okay.
There.
So it's
Welcome, Ellen. Last topic of the day will be also tomorrow's topic, which is H70. I thought it would be very helpful to get another orientation this bill before we take testimony on. Ellen.
Ellen Schakowsky, thank you. Office of Legislative Counsel. So I'm here on H70. This is a very short bill. This bill would amend to the definition section in 10 VSA 2801. And so I just want to take a step back and remind you what that is. So this is the what has been referred to as Act 59. The chapter in Title 10 that establishes the 30 by 30 and 50 by 50 conservation goals. So you heard earlier this session from VHCB about the inventory they've been doing, but this chapter established statewide conservation vision and goals. These goals are based on a United Nations conference on biodiversity from, I believe it was 2022. 190 countries agreed to this framework about conserving approximately 30% of land and water by 2030 and 50% by 2050. Since then, there was an executive order in the United States to do this as well. Again, it was a goal, it wasn't binding. And then further, at least 10 states have now also adopted these goals, including Vermont. A number of states have done it via executive order, but this committee worked on doing it in statute. I started reviewing them. The texts of them are not all the same necessarily, but they all include the goal of conserving approximately 30% of the land and or water. There's some variation by 2030, and most, if not all of those states have included that it be permanent conservation because that is at the international level what was discussed. And so this is about permanent conservation for the earth that has then been adopted at lower and lower levels of government in order to implement this vision that came about as part of one of the United Nations processes. And so this is a statute that establishes these goals. In the Vermont version with this statute, it directs that the conservation goals follow the framework of Vermont conservation design, and the approximate categories that have been, the approximate percentages should follow Vermont conservation designs and the categories they used there. And there are 3 definitions for the types of conserved lands that would fall into this conservation goal program, each having a different level of management. And so ranging from ecological reserve areas, which are similar but not necessarily the same as wildlands, which have the lowest amount of human intervention as part of the conservation. So little to no human management. Then there is a biodiversity protection category, and then the natural resource management category, which are areas that are subject to long-term sustainable land management. And so all of those categories added together, VHCB has worked with the Agency of Natural Resources to gather data on what land in Vermont has already been conserved, of that land, which of the 3 categories they fall into, and how close Vermont is to the 30 by 30 goal. And then what are the plans and strategies for how the rest of the 30 by 30 goal could be met. And so that, I think, then brings us to this bill, which makes 2 changes to that underlying statute. The first is on page 2, and it's amending the definition of the natural resource management category to add that, so these are areas that have permanent protection from conversion for the majority of the area, but that is subject to long-term sustainable land management, or agricultural land or forest land that is enrolled in the current use value appraisal program pursuant to 32 VSA Chapter 124, also called current use. The other change right below it goes with it, which is that under the definition of conserved, it's striking that it means permanently protected. And that is at least in part because land under current use is not considered permanently protected, because while it is protected while in the current use program, that land could be taken out of current use and then no longer subject to being conserved. I will just want to add a quick caveat that I am not the attorney who handles current use. I know that you work with the other attorneys on that, and so I can't actually answer too many questions about current use. But if you have questions about this bill and the 30 by 30 otherwise, I can assist with that. But if you have current use questions, you can get Bradley or Mike in here.
Are they sharing that now?
Yes. Yeah, and Kirby Keaton also works on it because of the tax implications. So yes, I think it is a shared area among a few of the attorneys. Yeah.
Representative White.
Thanks. So the idea basically is that the current use land counts towards our goals.
Yes.
As long as the land's in current use.
Yes.
And then and then we change the definition. I think conserve means like protected, doesn't it? So it seems a little strange that it's still in the definition, it's conserved. It should be something else, but that's just a thought.
And yeah, there may be a need to refine that if you're going to work on this, but when the committee worked on this, I think there were a lot of discussions about what conserved meant for purposes of this goal.
And so ultimately it would allow perhaps those goals to be met, but with no guarantee that 100% of the land conserved is permanently protected.
Correct.
Thank you.
Yes.
And I guess it's probably worth reading the rest of that definition because
Oh, sure.
it's permanently conserved for 30%. Then in the planning process, which is underway right now, which we heard about from VHCB, mid-planning process, they are looking into what would the role of current use be in meeting the goals? What is there a way of making it more permanent, but, you know, just like, is there some nuance in there that could be addressed? Those conversations are going on right now.
Yes, sorry. So the definition of conserved for purposes of this chapter is quite a bit longer than that. So conserved for purposes of this chapter means, currently it means permanently protected, and meeting the definitions of ecological reserve area, biodiversity conservation area, or resource management area as defined in this section for purpose of meeting the 30% goal. For purpose of meeting the 50% goal, conserved primarily means permanently protected and meeting those definitions: ecological reserve area, biodiversity conservation area, and natural resource management area. Although other long-term land management protection mechanisms and measures that achieve the goals of Vermont conservation design that are enforceable and accountable and that support an ecologically functional and connected landscape may be considered.
Questions for Ellen on this?
Just wondering why the permanently protected was struck from the first part of the definition, not the second part. What you would think to be consistent, it would be to be struck from both, or is it because the last sentence, the last phrase in that second definition for the 50% allows this expandable expansion to the definition, other long-term land protection mechanisms.
I think so.
That's why it's not struck. So it wasn't like unintentionally not struck. It was purposely left in the second sentence, as far as you know.
I wrote this more than a year ago, and I'm trying to remember, and I think so, but if you're gonna work on this, we can dig in if that's the intent. I honestly don't have a great memory.
It does seem like once you get into the past 2030 and you're working toward the 50% goal, then the second definition kind of supersedes the first anyhow.
Yeah.
No, because 30% would still be permanent. I mean, supersedes, it's not like you could undo the conservation of the 30% goal. But I know what you mean. I mean, it would be, right, there'd be more. Representative Hoyt and then Labor.
Yeah, I might have answered my question. So based on the current statute, 30% goal like that, all that has to be permanent, right? Protected 100%.
Yeah.
When you get to the 50, there can be some that is not, if there's like a long-term sort of mechanism to protect it, even if it's not permanent.
Yes, and there's supposed to be some proposals, I think, from
Okay.
HCB on how that would be accomplished.
Yeah, thanks, that's helpful.
If there are other tools identified.
Yeah.
Meet the same goals. Representative Labor.
Thank you. What I'm not seeing in this bill is the penalties for withdrawing. Say you got a 50-acre parcel, you want to give 10 to a family member. There's a penalty for withdrawing that 10 acres that's substantial. It's based on current values, market value.
So this bill does nothing to impact the current use program or any of its structures. So you're right, because we're not changing anything related to current use. Simply considering whether or not current use should be explicitly considered as part of the 30 by 30, 50 by 50 program.